We have different clocks with different times, and it's not quite 12:30 on my watch. All right, you have your cell phone, which is the most accurate. Oh, okay. So good afternoon. Today is Tuesday, June 17th, 2025. Members from both the House and the Senate have convened today for the Committee of Conference for House Bill 421 FN relative to notice of tax exempt status filing procedures by town officials or offices. At this time, we have a quorum, so I will open the Committee of Conference on House Bill 421 FN. So to begin, as we all know, that the Senate made changes to the version of this bill that was amended and passed the House. So in order that the House conferees have a very clear understanding as to what the changes the Senate amendment actually does, I'd like to step through these changes on the side by side and just have a brief discussion, if necessary, on each point. So referring to the side by side with the reference point of the Senate Amendment 1964. So the first change has to do with just the analysis. And the House would be okay with that. That makes sense. The second change noted is that the Senate version simply changes the notation of 2 months to 60 days. That makes perfect sense. And then we come to Roman numeral 6, and the Senate added in some language. So I would ask that the Senate explain exactly what this change does to the bill, because there's seems to be a little bit of confusion as to what exactly is going on here.
Well, certainly, we were trying to cut down the work on the clerk and the number of notices they had to send out. So the first part was, hey, just post the forms up there. And then the second part is 7 days after, if there's somebody who did not file, just send them a note. Simple as that. And hopefully the percentage of people that file, be up 90% or whatever. So the number of notices they would send out for the Senate version would be 10% of, what the House version would have been.
Okay. So to be clear, that the House is concerned with the number of mailings that is required based on the Senate amendment. In my clear reading of the version as adopted by the Senate, requires multiple mailings, and I'm to be honest, having trouble. I hear your explanation, but when I go and look for that in the bill language, I'm not seeing that.
And
so,
can you point out where
yes,
you believe that it's multiple mailings?
Yes. So if we refer to the Senate amendment. That's 1964, and I have a printout here as posted on the General Court website. Under Roman numeral 8, my understanding is that, so just to be clear, there's two forms. There's an A9 form, and there's...
Give me page and line number.
So it's Roman numeral 8 of the amendment.
Why aren't we going off of the Senate amended version?
What? Yeah.
As amended by the
Yes.
by the Senate.
So it would be page 1.
Page
It would be
1.
line 4. That whole section, Roman
Line
numeral
4.
8. I
All right.
apologize. Okay. So to me, when I look at this, it says the cities and towns shall annually mail the forms. So that's your first mailing. So you need to mail each form 60 days before the deadline. And for the A9 form, that deadline is April 15th. And for the A12 form, that deadline is June 1st. So right there, that's two separate mailings.
I'll tell you what, it is not our intent to have two separate mailings. Why don't you take a break, get an amendment that you think is, does it, and then we'll come back and talk.
Mr. Chair,
Yep.
so just know that's in your House version too. If you look at the side by side, right in this third block box, section 8 of the House version says cities and towns shall annually mail. So it's already the position of the House that they had to do that. The only thing we did was change the 60 days. And then again, that second sentence piece was to do two things, is to deal with the complaint that this was supposed to fix was people who forgot to file was the problem, because for charities, people change on a regular basis. And so someone may not realize the A12 needs to be filed. And the goal was to capture those people and remind them. So the current law is what you have there, is what the House passed. The only thing we said was that there isn't an additive mailer. It's if after the filing date ends, someone who in the previous year had filed, didn't file, to those people that didn't file, send them a notice. So that's going to be a fraction of the number of people. And the idea is to remind them that you were supposed to fill out this A12 to get your tax exemption. You didn't do that. We're giving you a chance to do it. So understand, that's the only thing we added, was the allowing the provision to catch those people who forgot because possible changes in personnel.
So
From
in,
my discussions with the senators, we're not wed to this bill,
Yep.
okay? We were trying to do the right thing for the person who filed the bill over in the House. And if you would like to change something, we're certainly welcome, and able to entertain it. But that's,
Yeah.
we're not going there, as far as I know.
could you, you're not going there? What do you mean by?
What I'm saying is,
Yeah.
I'm not gonna be writing an amendment
Understood.
to do anything.
So,
If you guys don't like our language, then if you would like us to consider something different, please write it and give it to us, and then we'll come back.
okay, so verbally, I was going to go through it, and just to be clear, I have 5 points that need changing. So, as far as us drafting something, right? Can we come back sometime today? Is that what you're proposing?
Well, I'm on the House Bill 1 and 2
understand.
committee of conference. I shoehorned you in here. If one of my other members on this side, can be there, then that's fine, and they can advise me of what went on. But, bottom line is that there was a mailing that was supposed to go out ahead of time. We don't care that mailing ever gets done, okay? In fact, posting the forms on the website, if you had email addresses, fine. You put them in a folder, hit send. I'm good with that, okay? If that's what you want to do. But we do want at some point from your language, if the mailer is going to go out, that mailer be, hey, you forgot to file. It'll be a lot easier if you come in and do it now.
The House is in agreement with what you're proposing. Personally, I'm fully on board because I do want to cut down on the number of mailings. The problem is right now is that with the wording that's in front of us, I'm not seeing that. Would anybody else like to chime in on that? I'm not seeing that what you're verbally explaining to me is what's happening in the Senate version as passed by the Senate.
It's in section 6 at the end. Cities and towns shall give notice and post blank copies of proper forms in a manner similar to other public notices, right? 60 days before the due date. And then the next line, 7 days after the filing due date, municipalities shall send notices to any charitable organization approved in the prior year that have yet to file. So if the 7 days they haven't filed, then we send them a notice saying, you didn't file, you got this exemption last year, you want it this year, file your paperwork. So that's the section
right.
where we do that.
And I understand that. So cities and towns shall give notice. That's one verb, and post. So when I read that, shall give notice is the first mailing. And then the second action would be to be posting these blank documents. And then furthermore, after those two, because we're talking about 2 forms. So the 60 days prior before the filing deadline, then, as you describe, it says 7 days after the filing due dates, because again, there's 2 forms, so we have 2 due deadlines. If if the municipality has not received these forms, then there'll be a mailing sent out. So in my mind, in the House understanding is that, I guess step one would be you do that initial mailing.
So again, it says
Yeah.
post note, it shall give notice and post blank copies of proper tax forms in a manner similar to other public notice 60 days before. So other public notice is usually 2 places in town, in your newspaper.
Right.
You know, whatever the other public notice is, not a mailing.
But
So
it's
that's
and,
public no- it's how you
how-
give public notice to a meeting or anything else.
Okay, would it be more clear if it said shall give notice by posting blank copies? Again,
If you want that change,
okay,
I'm not opposed to it.
yeah,
Okay? Again, section 1, you guys put in, all right, we didn't really, as far as I remember, get any testimony on section 1, but that's the first place that you had. If you want to rewrite that, fine, but
okay.
again, we're here,
Yes, I see that you're here, and so I thought that it would be acceptable to have a conversation and then, verbally come to some agreement and then to have that, committee of conference report drafted by OLS.
What were
So
you
in this
trying
committee
to-
of conference, I guess we're going to do it differently, which,
what were you trying to do in section 1? That's a new paragraph. You guys put it in there. You guys were trying to do the mailing. Okay,
Well-
or what was Representative Pearson trying to
Correct.
do?
well, yeah, he wanted these mailings to be mailed out ahead of the deadlines. The concern is that when we read the bill in conjunction with the Senate amendment, we're talking about multiple mailings, potentially up to
So,
4.
in that, are you comfortable with changing that to the language down below that says they have to post them someplace?
Posting
With
would
your
be fine.
wording- With your wording so that it's clear that it's a posting and not a mailing.
And we also have one other option that we could do,
And that is?
and that is to just not concur
That's up to you.
and have.
Again, section 8 is your language. The only thing we did is change 2 months to 60 days. It's already the House voted position, right? The only section that we changed was in that Roman 6, and if you're saying that the sentence says the cities and towns shall give notice and post blanks of copies of proper tax forms in a manner similar to other public notices is confusing, which I don't think it is, but I think everyone knows how a public notice is done in a community. Town clerks do it all the time for meetings and across the board. So I don't know that that's any different, but if there's language you think in that 2 sentences that'll make it clear.
Could we take a brief caucus? Could we break to caucus very briefly?
Sure.
Thank you. So at this time, the House will take a break for the House to caucus, and we'll be back in less than 5 minutes.
Okay.
You're trying to say your clock is with the austere?
Okay, Senators, so the House feels that in response to the Senate's amendment, that there's too many changes that need to be made during this committee of conference. So therefore, we would like to non-concur. And it's important to get this right. So the idea is that the prime sponsor and those interested parties can get together and get the language more precise. And I think that's the best way forward than trying to keep everybody here and rush it. So per House rules, I will need to
Write a report.
call a vote.
You guys vote.
Correct.
We
So
don't vote with you.
yeah. So per House rules, I will now call the vote to non-concur with the Senate amendment. So if you are in favor of the motion, you'll vote yes. If you're opposed to that motion, you will vote no. I will call the roll. Representative McDonald.
Yes.
Representative Walker.
Yes.
Representative Majori.
Yes.
Chair votes yes. So the motion to non-concur with the Senate amendment is accepted by a vote of 4-0. And
And I have polled the senators, and we're comfortable with that.
so your vote is unanimous. So without objection, House members, I will put this committee of conference report on the House consent calendar. Okay? All right, so I will head over. I don't need to do anything
Still gotta do a report.
for the House clerk. Correct. Okay, so all right, so I will take care of that, and I would like to thank the good senators for your time, and I will now close the committee of conference on House Bill 421 FN.
Good afternoon, everyone. I'd like to reconvene the Committee of Conference on 701 FN. Senator Prentice, thank you very much for your work in sending us the revised version. A lot of extensive information in there, so thank you. House members, have you had it? I sent it out this morning. Senator Prentice got it to me, I think it was around 10 last night, 10:20 or so. And unfortunately, being an old guy, I went to bed early and didn't see it till this morning, but I sent it out as early as I could, so.
I gave you a preview first. And then
Yes, you did. And I did forward that earlier in the evening, so. Anyway, I think that'd be a good point of departure unless anyone has any objections to that. Representative Leon.
Thank you, Mr. Chairman. I want to thank Senator Prentice for putting this together. I think we're almost there. I know that for me, there's just one part that you had in the location. On this one that we have, that Representative Husselring passed out, it's on the page 3 on line 9. You had added that it needed to be done in cooperation with an eligible facility instead of at an eligible facility. The problem is not every single one of the facilities may have an active IRB if that needs to be done. So if it can simply be directly supervised by an eligible facility, I think that gives all the protections you were looking for without running into some of the problems that are the reasons why patients just end up not getting this care because it ends up being too much of an administrative hassle.
Yes,
Chair
Senator
McDonald-
Prentice.
Thank you, Chair McDonald. So Representative Leon, when you say in supervision with an eligible facility, what does that look like? So if an eligible facility is, say, Dana-Farber, okay, so when you say in supervision, and what do you mean?
Oh, thank you for the question.
Or the visual, just give me an example, please.
So when you have a hospital that has a stood up IRB and there may be another facility that they can do that, within that, they're going to need to have an agreement in order to have that supervision in order to allow that protection to cover them. That's not the sort of thing that we would need to cover in state law. I believe your language said in cooperation, or did you say it was in eligible facility?
I took out in cooperation with and put it at, I put it
At.
at an eligible facility.
Okay, so you had at an eligible facility. And that gets us a whole lot closer. But if we have one of the facilities that it's closer, let's say that the provider is going to travel to a Salem facility that's part of the same umbrella network, but isn't the one where they have the active, whatever the federal title is for that we're relying on for this human protection. If they don't have it active at that satellite location, say in Salem, but they do have it and they already have supervision requirements within their hospital rules, that would be something to cover. I mean, honestly, if somebody's doing this, if they're trying to pierce this, it's because they're going to sue. And if they don't think that there's enough paperwork on the hospital side where they already have supervision because somebody's overseeing it, you know, there's a certain point where we can't put every single dot and wiggle that we want into law, but I think that this would be well protected and not lead patients out if they're not able to make the full distance to the site that does have that federal designation.
Okay, let me just think about that. Thank you.
Senator Abbas?
How difficult is it to get the federal-wide assurance? I mean, are we talking about is that an unreasonable ask? I mean, I'm not familiar with the process of getting that, but I mean,
It's not uncommon for that to last longer than a person has to be eligible for the procedure or possibly to live. It can take weeks, months. It depends how much previous experience they have with them. So this can be something where the clock would run out on that patient in order for that facility to get the federal designation, rather than just relying on the supervision.
once they have the designation, aren't they at that point good to go? Or they have to get it for every single patient? I mean, I feel like I understand like to get them up and running, it could cause a delay, but once they have it, aren't they at that point? I guess what I understand both sides of it. I'm just wondering how tall of a
So
order is it for us to want them to have it in New Hampshire?
I would say it's a tall enough order that people have had to fly patients from one state to another in order to go to an active site. We're trying to reduce barriers. I think that I greatly prefer the language that we're suggesting, though we do get most of the way there with yours.
Representative Kesselring.
So I just want to add, if it's a satellite location, another facility down, let's say Massachusetts, for instance, and they want to open an office here and still practice and go back and forth, this would protect that situation also. So I just want to add that to the conversation.
But I'm saying once they get that federal-wide assurance,
Could take years and years, according to what I've found in research. So,
but my question is, once they have it, and then everything's all set, right? I mean, they're not gonna have to keep getting it on a patient by patient. They just-
It's not patient by patient, but there are ongoing compliance costs and reapplication costs.
and then also moving laboratories and other facilities to New Hampshire based on the current wording. This actually helps them to not have to move all of their facilities here to New Hampshire to be able to get that classification.
Senator Prentice, did you want to say something?
I'm gonna hold right now and keep
Okay.
thinking.
I saw you put your microphone
I
on.
started,
so-
yeah,
Okay. Okay, okay, that's fine.
Going to directly supervise, that would indicate to me that there is a staff member or a medical provider from the parent organization physically on site at the eligible facility in order to give this direct supervision. Am I reading that correctly?
Representative Kesselring.
Yeah, I would say that,
Direct supervision?
yeah, I would say that because we're talking here about administrated by the health.
Microphone.
We're talking specifically about who it's administered by, the healthcare provider. So we've already stated further below that it's, that this needs to be a New Hampshire licensed physician, but then we're saying directly supervised by an eligible facility. So it has to be that facility that we outlined. But yes, that doctor has to supervise there. So yes, it could be another provider from another state, I would say, coming into that facility here in New Hampshire to help the physician that is currently doing the treatment. Does that make sense?
Yeah, but, and then just to go back on that, just to follow up on Senator Abbas, if I may, we don't really know what's involved in the federal-wide assurance for protection, what's involved in getting that eligibility, correct? Do we know I mean, you said it could be years, could be months, could be weeks.
I mean, again, we could get that information again. It's not going to be prudent for today. I just
Okay.
know that
Microphone.
sorry. We do know that it is a lot to do that. And
Right.
again, my comment about moving the labs here and all that stuff, there is a lot more to do with it to make sure that if they're practicing a specific thing. So
Okay, thank you.
Representative Leon.
Thank you, Mr. Chairman. Looking at this, I do understand why you want to have all of these protective details within the statute. This almost looks like a place where we may want to put some administrative rulemaking so that they can get those specific details on the direct supervision, so that we can clarify that language in a way where that can be updated as necessary through the rules process with the department, as opposed to trying to wordsmith in a document like the statutes. Because direct supervision in many other places within the licensing boards is a common rulemaking job.
Yeah, to define what that means.
Correct.
Anyone else? Any other thoughts?
Well, on this subject, or
On this subject, sure? Or any other portion of this document?
one housekeeping issue I came across that just, and I did speak about this with an attorney that's in the audience. And when it came to the claims that are brought and the immunity, I
What
think-
page are you looking at?
so if you go to page 2 on lines 23, and then you go all the way to page 3 that ends on line 9, that is where you're talking about a situation where someone's immune from liability, right? Which one of the issues I kind of spotted was, well, they're not immune from willful misconduct. But let's say you have a situation where someone's prescribed a medication, whatever medication, 1 gram, they administer 20 grams, and you essentially overdose of that. By doing that, it kills you. That's medical malpractice. Now, I don't think having a general negligence standard that would defeat the whole purpose of the immunity provision. But there was some thought on putting the term reckless, which says willful or reckless. It says willful misconduct, but you can put willful or reckless misconduct. I think that would cover some situations where basically it wasn't really the experimental treatment, is that they committed gross malpractice by doing the example I just gave. So I did try to look for what reckless, a good definition of it. This is from the New Hampshire Supreme Court in a 2024 case. It's reckless conduct is characterized by the creation of a substantial and unjustifiable risk of harm to others by conscious and sometimes deliberate disregard or indifference to that risk. Additionally, reckless conduct is much more than mere negligence. It's a gross deviation from what a reasonable person would do. In other words, for conduct to be reckless, it must be so unreasonable that a person would never engage in it. So I don't know. I don't think that should be a problem. I think that covers it. I don't think that defeats or nullifies the intent of this. I think I think being immune from simply misapplying whatever the treatment is. I don't know if there's an objection to that.
Thoughts on that?
And for the cases, Vermont Telephone Company, Inc. versus First Light Fiber, Inc.
And again, you're starting on page 2, line 23, you said?
Yeah, so if you go where willful misconduct's on page 3, lines 5 to 7. So where, I think line 6 is where it actually says it.
Okay, yeah.
It said willful or reckless. I don't know if that,
So you want to insert the word "or reckless misconduct." Not hearing any objections from the side of the table. Okay. Any other thoughts on this or any other subject within this document?
Not on this, but I want to talk about eligible patients, and
Where are you looking, Senator?
so I'm just going to go to the first page under definitions. And it's not so much about the definitions, but thinking about, and I think Representative Leon, you might be the person to answer this question, but follow me on this here. So I live in another state. Say I live in, because you've talked, I just in the context of, you talked about people traveling here for this kind of care. Okay, so they'd have to establish a relationship. I'm coming out of, say, the state of maybe Utah, or we'll pick Utah, and I'm unable to get this care in Utah, but I can come based on the changes here to the state of New Hampshire to get this care. So if I'm leaving Utah, I have to first establish a relationship, a patient relationship with the healthcare provider. And here we've designated that it's going to be a physician healthcare provider. And we have, a way to establish remotely consent and do an initial consultation. So they become a patient of a New Hampshire physician. When they become that patient and they come here for care, are they this is a two-part, if I may, Chair. So are they leaving behind the care that they've already established? Maybe they're in, they're under palliative care, moving towards hospice. Is that now, I don't think the word abandoned, but where does that line stop and they clearly come into being a New Hampshire patient? Because then I want to talk about what happens when they're in New Hampshire.
Thank you for the question, Senator Prentice. A lot of times, especially when you've reached the stage when you're trying to access these types of drugs, devices, and procedures and biologics, you aren't just working with one physician. You are working in a collaboration with several different healthcare providers, between those who are dealing with your pain, possibly those that you were talking to, in order to have the appropriate counseling as you're facing this stage. You may have a general practitioner still, as well as a specialist in your area of oncology, and maybe an additional one. I do know that many of these physicians work in very solid teams, and they're very happy to collaborate with others throughout the country as necessary to help their patients. the times that I've heard about somebody reaching out to a representative of one of the companies on a Thursday night or a Friday night when they have a patient who needs to have access to one of these life-saving drugs, the doctor calls. They call that person. That person can then put them in touch with one of the key opinion leaders, one of the top doctors in the world, say for a type of brain cancer, because I had experience with somebody close to me. They called, and that specialist in brain cancer returned a phone call within 10 minutes in order to get that young man in. So it's collaboration within people who are doing this innovative work to really be on the cutting edge of saving lives is common practice. So I don't think that line between where they become it's not abandoning care to go from one provider in one state to another. While they're in the state of New Hampshire and undergoing that in the state of New Hampshire, I would believe that any care related to what's happening in New Hampshire would have a relationship with our state laws. But what's happening in their home state is separate when that care is administered in their home state.
Sure.
So I've now found the appropriate word, discharge, not abandon. I'm thinking about being discharged from the care of one medical practice. And being transferred to another because you are choosing to get that medical care in a different state.
Thank you. That's not normally how it works when you're at this stage in the process. You're not discharged from one care. It's a collaborative effort between different teams. Some of it ends up billed to one doctor or the other doctor based on where you are in the care. But it's not the same handoff that you have when you're still in a healthier state of life, where you truly can be discharged and handed off from doctor to doctor. That's not how it works when you're fighting for your life with these innovative treatments.
May I?
Sure.
I'm not contesting the point about fighting for your life. I'm asking whether you're saying this is not the way you know it is, but is it possible that if a physician doesn't agree with a patient's choice for care that they want to obtain, that they could discharge them from their practice?
If you give any sort of scenario or hypothetical, there's probably going to be a way that happens. If a patient's discharged by their other physician because they're looking to get care here, I'm not sure how that would have relevance to the statute.
Yeah.
Continue, sure.
Okay, so thank you. Relevance to the statute, it's actually relevance to, my concern is that if they were to be discharged and they come to the state of New Hampshire and this now becomes their home state. So what are we then, if they are a home state resident, they're in a home state community, and they are not able, say they don't have insurance coverage. Is there the possibility that home communities are going to be home communities are the point of last resort for people who are, in a state where they need assistance. So I'm just thinking about that. How, if they leave one practice or they're discharged from their practice, they come here, now this is their home state. Has there been any thought about what that might look like?
You're saying that this would make us into a sanctuary state for people with terminal diagnoses?
No, don't.
Okay,
I would appreciate
okay.
you not.
Okay, I'm
putting
just
those
trying to
words-
understand this.
What I am saying here is if you leave the state where you came from and you come here and you become a resident here, because you've been discharged from a practice, you decide you're going to make this your residence to get the care that you need, and then you need assistance either with medical insurance, you need Medicaid, you need housing, you need help along those lines. Who's responsible for that? As it is right now, it's the local community that becomes responsible for that. So
I'll give you an example of a single mother with a couple school-age kids, unable to obtain the care that she needs in her home state. What happened was a charity would fly her and her daughters with her to the treatment. A charity put her up in a residence while she was receiving that treatment and flew her home between courses of treatment. That's generally the way this works, because while you're going somewhere to get access to care, you aren't uprooting your life to do that, because we're not talking about something where you're essentially going on dialysis and hooking yourself up to an ongoing machine. You're talking about coming in for courses of chemotherapy that you need to recover in between the administration. You're maybe coming in for a one-time treatment. This This isn't something where somebody's going to uproot and move to New Hampshire in order to be closer to the provider, because that's going to be even more disruptive to their life than to simply come here, get the care, and then go back home, especially because there are so many compassionate charity pilots who will fly people for that treatment.
I'm gonna stop for now. Thank you.
Do you want to take a 3-minute break? All right. If we may.
Oh, absolutely, absolutely. Do any of us want to have a break or a caucus or anything? Or are we good?
I think we should, because I got a thought.
Okay. Okay, I'd like to reconvene the Committee of Conference on HB 701 FN. Senators, do you have anything you want to share? Or?
Yeah, I think Senator Abbas had some questions he wanted to add, and then we'll.
And it's just a question, because we're trying to make sure we understand this federal-wide assurance. So when a medical facility has this federal-wide assurance, is it limited to, they must perform all of their operations at the physical address where they got the assurance? I mean, so let's think of a large hospital like Mass General, right? They operate in New Hampshire as well. So if they have it and they have a satellite in New Hampshire, why they would be able to provide that treatment at the facility in New Hampshire? I don't think that's a problem. Am I correct when I say that?
Representative Leon.
I'm not certain if that's the case, but if your intention is to allow allow one of these from another state to provide protection in New Hampshire, we could say a healthcare provider, an eligible facility or a satellite location of FWA of an eligible facility of a facility with that in another state.
So I think that would cover it, because I'm trying to figure out the examples were given, someone's flying here, coming here from whatever part of the country, all the way to New Hampshire. All right. I guess if they're traveling far, but there is a federal-wide assurance facility somewhere else in the country, why aren't they just flying there? That's what I'm trying to wrap my head around, is that I wouldn't think that assurance is limited to the brick and mortar of its operation. I mean, I don't see why they can't have a satellite. And is that limited by state boundaries now? I mean, is it because they're crossing from Massachusetts into New Hampshire or Maine into New Hampshire? I don't see why that would be a restriction. It's a federal law, not a state.
I think you're mixing topics. Usually the reason why this treatment is not offered isn't because of the scientists, the doctors, or the federal government. It's because of risk of legal threat. And when there are not enough protections, there's a lot of companies, there's a lot of doctors who would rather not risk a lawsuit and would rather simply not offer the care. So linking to one of these facilities in another state has no problem. It's not something that would create an issue. That would probably give the protection that you need in order to feel comfortable. But the legal protections in this statute are what is going to save people's lives.
Representative Kesselring, did you have something?
Yeah, I just wanted to add, I mean, I did agree and like what you said. If there's a better wording for it to say that they can open a satellite facility or operate, then let's do that. I mean, that's basically the crux of what we were trying to accomplish. So, does that make sense?
I understand that. I'm just still trying to wrap my head around how, by removing that, the problem is when you remove that language, from the definition of the facility, the eligible facility, I think it opens up a whole other can of worms, because now you have these organizations that are going to be conducting experimental, procedures, and to get under the federal-wide assurance, they're getting government grants. There's a lot of things that go into that, but now they're going to be doing it offsite somewhere else at a satellite, but they don't have that federal-wide assurance, which I would think conflicts with the federal law. So I'm not sure. I can appreciate what you're saying, but I don't think that in a reality, if that's the case, anyone's going to do that if they don't have the federal-wide assurance, because they're now violating the federal law where allowed them to do this experiment in the first place.
Representative Kesselring.
So I mean, again, the recommendation would be to just go back to the original that you guys suggested last night. That was the an eligible facility.
I think that it would be required to do again, I'm not an expert on federal-wide assurance. That's why, please, if I'm saying anything that's incorrect, please help me.
Mm-hmm.
But what I gather is that if they need to have that in order to be doing this experimental research, by then doing it somewhere else or allowing someone else to administer it they don't have the federal-wide assurance, it seems to me like they're not complying with the federal law, which it doesn't mean they can't do it anyway. That's a federal issue, but I don't see these places doing that in the first place, because it would kind of jeopardize their grants. And that's just the way I'm looking at this now. So we want to encourage them to come here and do it. I think they're going to have to do it the right way. Otherwise, they're not going to be approved by the feds in the first place.
I mean, I think if that's the only sticking point right now, I think here's the pen. I mean, we can do this now, but at the end of the day, if that's the only issue you guys have left, then I think we can get over that.
Well, I think rather than worry about unintended consequences as written, I assume they're not gonna mess up their federal funding that they're getting. So I think as it's written, at least because the unintended consequence, that's a whole nother topic to discuss.
Representative Lucas, did you have something you wanted to offer earlier? or-
Yeah, and I don't have a legal background. My background is healthcare. I'm a retired physician, but I look at this as an opportunity to augment care, not to supersede care, not to disrupt the relationship that the patient has with their healthcare team from wherever they're coming from, and it's not likely to create professional jealousy or turf war, if you will, in these situations. And granted, there won't be many. Patients have exhausted their treatment opportunities, and this is simply offering another option. I mean, I think in some ways it almost is like compassionate care, because this is another opportunity for the patient to pursue if they wish. There's nothing mandatory about this. I think it's fairly straightforward, and in a lot of ways, it's just common sense.
So I think where we're at, if I'm hearing this right and summarizing, Senator Prentice gave her red line amendment as we began this. I think that's where we're at with the addition of reckless to willful misconduct on page 3, line 6. I think that's where our comfort level is. I got to be very honest. What I thought was a very straightforward bill at the beginning, as we've talked over the last couple of days, I'm getting a little less. There's been a lot of questions that have come up, but I think that this is where I'm at right here with the amendment that we have in front of us. I would probably also point something out on page 3, line 19. It says any patient diagnosed by a physician with a terminal illness. I don't think I think it's any physician diagnosing a patient with a terminal illness, not the physician with a terminal illness. So that's just some housekeeping there that should probably be up. But I think that's where we're at right now on the Senate side.
I think your that typographical issue is also on page 1, lines 5 and 6. So if we correct it, that would cover both of those.
Yes.
Lines 5 and 6?
On page 1.
Yeah. Okay. Representative Bland.
Thank you, Mr. Chairman. Senator Abbas expressed a desire to allow facilities that are satellite locations of those with an FWA in another state to also be included. However, our definition of eligible facility does not include that. So if we were to also change that language of eligible facility means a licensed New Hampshire institution operating under this, or a satellite location of an institution licensed in another state operating under the FWA. Would that be acceptable language?
I think that as it's written, it would include the satellite, because
No.
I don't. Do you think it does? Yeah. I just assume. I mean, so I don't think it's a necessary change, but I don't think it changes. I don't think anything changes by putting that, because if I don't think they're going to be limited to the brick and mortar, like one physical address. I mean, they can have multiple addresses or locations in a state. It wouldn't make sense that they lose the ability to, just because they cross a state line, but I don't know the answer to that. So if they have a satellite, that would, I guess, cover that. If there is a federal regulation limiting to you inside of the state within a particular state, I guess the satellite language would cover that. But then again, they're going to have the same problem. They'll be violating the federal wide assurance laws if it's, but either way.
But you state that you're assuming that a satellite location in another state is covered underneath the same FWA. But you don't, but this says a licensed New Hampshire institution operating under the FWA. Depending on how that's interpreted, we could run into a problem where somebody claims that there's not actually this protection because the institution with the FWA is in Massachusetts, and because they're not, may or may not be listed and some of those technical details on it. I think that it'd be a really simple change to state, to add the eligible facility also being a satellite location of an institution licensed in another state operating under that.
I think that covers them under the New Hampshire law. What the point I was making, I don't think it covers them under the federal-wide assurance laws, but that's again, that's a federal issue that's not our concern. I'm just trying to make sure. I think we all agree we like the policy in general, but we want it to work, and we want people to take advantage of this, both patients and medical providers. If we set up a system where it doesn't make any practical sense for the medical community to do it successfully, I don't think we're putting our best product out there. So I don't, whether it's a satellite or not, I don't think changes much, at least from how I read it. And they want to, that's up to them to deal with the federal law.
Representative Kesselman.
So then I have a question for you, because based on your terminology of reckless, we're protecting more. Do you think that the word supervised there in the text on page 3 that we originally put in specifically enough kind of covers that in some ways or not?
Wait, are you talking about the reckless conduct? Or are you talking
Oh,
about?
I was referring to the fact that you were trying to cover another thing with the reckless, but I was going to say that it's almost like we're kind of covering two different things, but by adding in, supervised, it still gives the ability to that physician to have the other person come in. Does that make sense? Because again, if we're adding another or another whole section of definition to creating a satellite facility, you said it's probably already covered, but we're only adding supervised here. That physician could still supervise somebody else coming in from another place. Are we not then covering what could be? What I'm saying is trade reckless for supervised, let's say, in that mindset.
Well, as this is written, this is not me being critical. I'm just saying, if you ask for me to write you an essay on what this means and how it would be applied, any form of ordinary medical malpractice they would have immunity from all forms of it, including a situation where it had nothing to do with the experimental treatment. They just gave them 20 times the dose they were supposed to. It was by accident, so it's not willful. It was a mistake. But I don't think when we're talking immunity, it's really, we want them to be immune from any complications of the medical treatment they're getting that's at the experimental stage, right? But I would hope reckless covers that. Now, I'll say this, reckless doesn't solve that issue, but I think if you don't exclude, the problem is if you put ordinary medical malpractice in there, you're gonna have a bigger problem, because that would just negate the whole bill. So I think what I'm getting at is reckless at least offers some protection for when they did something that was very unreasonable in the application of the treatment, not the treatment itself. If that makes any sense.
Yep.
So I think keeping reckless is important. The supervision part, I'm not sure from a legal perspective, what the definition of that is. Meaning, what is supervised? The administration of the medicine, their reactions to it, how long do they have to supervise? I don't know where that starts and ends. Obviously, if they're physically there, I think putting supervision in there could also restrict this. I mean, they're going to require a lot of supervision that they may not be interested in doing, especially when it's someone else administering the treatment. So that could have a reverse effect and make this less available. Really, because the business side of things may not mitigate it.
So to go back to what you were saying before, is this the last thing that you have as a concern? Because I do have one other thing that I wanted to add, but I want to make sure we get.
What's the last?
Well, the last thing I wanted to add was a possible name change at the top of your paper that I handed out. We talked about yesterday, changing it to the John. Again, if I get these names wrong, I apologize. Lewicki and Michael Yakovich, Right to Try Act.
I got no problem with that. That's the easy, that's, yeah. That's, I'm 100% on, that, we don't need a caucus that one.
Okay, so in terms of the ultimate Representative Land, did you want to speak?
Yes, Mr. Chairman, and maybe what you were about to say, but it sounds like we're very close. I don't know that now that we're 4 minutes till the end of the hour, if the Senate could draft the language that they're willing to accept with that title change so that we can look at that and hopefully within just a few minutes when we do come back, since we're just about out of time, I'll be ready to sign, assuming we agree.
Is that, how does that proposal sound? Is the Senate, first of all, amenable to another meeting?
But I think the change you want was respectfully a House suggestion involving satellites. So why don't,
No. Where we're at right now is the draft that Senator Prentice handed out with the addition of the word reckless after willful.
Okay, and the change by Representative Kesselring in line 9 on that same page, is that something unacceptable or
That's page 3. That was
page 3? Yeah, it's the same page as.
Yeah, we don't agree to that line. We agree to the version that Senator Prentice,
In cooperation with an eligible
yeah,
facility.
the healthcare provider at an eligible facility.
But you're agreeable to everything else?
Yeah, we would agree to everything else, and, we just want to make sure the change, we're not talking about physicians with terminal illnesses.
Yeah,
right.
We want to make sure that gets, and then as far as your name change goes, I'm fine with that.
so the terminal illness typo there's 2 of them, just remember, right?
Correct, on page 1 and on page,
Page 3
Three.
on line 19 and page 1 on line 5 and 6, right?
yeah.
Okay. All right, if it's amenable, then I could go to the OLS, and have the draft prepared, and is the Senate amenable to another meeting tomorrow, or?
I'm here tomorrow, so
I'm here tomorrow.
Okay.
Let me tell you.
How's
the
Tom
time.
Free, Senator Prentice?
Let me look at tomorrow. I know that I have a 3 o'clock meeting that I cannot miss.
I have a question.
Sure.
To vote on this, if we're all in agreement with what they just
At
said,
12
do we
o'clock
have
and
to have
3
the written
o'clock.
language in order to vote?
You have to button it up.
I'm asking the question.
it's probably a good idea.
It'd be, yeah.
I was on the bail reform that what we agreed to, and then when it was, the written product was not even remotely close. Wasn't
Okay.
our finest moment as a legislator.
How does 11 work?
Yeah, because you and I have that other meeting
Yeah.
at noon, right? Yeah, 11 is fine for me. Other House conferees, or?
I have another one at 11, but I can give you my input and maybe duck out of that one if necessary, if you need me.
Representative
I
Lucas?
have an 11,
Okay.
I have an 11 that I'm in, but
I could do 10 as well.
I have a 10.
Representative Lucas, are you busy all morning, or?
No,
10:30 or an 11:30 work.
pretty much between. I can't.
I have one at noon, and I have one at 3. I think I'm okay in between.
10:30 or 11:30, because I have a 10 and 11.
Okay.
So
10:30 works.
Representative Lucas, you're not available, though.
Oh,
That's
okay.
fine, that's fine. Representative Leon, you could be?
I'd be available at 11:30. I'm
11.
sorry, at 10:30. Yes.
Okay, 10:30. Representative Kesselring?
Yep, I'll be available.
All right, so we need at least 3 of us for quorum, so, yeah, so. All right, so 10:30 tomorrow to finalize the language. Is that amenable to everyone?
and yes, and who's drafting what, just to make sure we're all.
I will bring this to, well, actually, yeah, and I have the electronic version, because I know OLS wants that. And I'll explain the other changes to them. Position of physical, terminal illness on those 2 pages. Inserting the word reckless, and the other thing was the at an eligible facility. I got that right?
I did think that we had agreed to add reckless in exchange for the supervision. But we can add that. We can always, if we don't get to a,
That's not my impression, but
I think the
Well, let's-
supervision may be more restricted than you think, because without requiring the constant supervision of it may actually obstruct this. I'm not sure that's the way.
We'll come with it with the rec list and we'll see where we go.
Okay, and again, it would be willful or reckless shall include, but is not limited to, any conduct intended to hasten the death of the patient. Is that, literally, we're only adding the words or reckless there.
Yes.
Right.
Okay,
And that
okay,
covers some of the, I would think, egregious errors in the application as opposed to, the treatment itself.
Quick question.
Representative Kesselring.
So, I mean, if we go to the original language of eligible facility, get rid of supervised, would you be in disagreement with what Representative Leon said, maybe adding another thing, even if it is covered under law, putting in another thing about or under the facilities, put it in there that could have a satellite location just to cover us, or would you be against that? I'm only asking.
If it's a satellite location of a federal-wide assurance, I don't think that changes I don't think that changes much on our end. I'm not sure that's gonna work under the federal-wide assurance laws, but that's,
But that would still cover us if it is approved by them, correct? There's no other issue with that you'd see?
anyone see a problem? I
I
don't,
mean,
I'm not sure that's gonna work in the real world, but I don't have.
yeah, I mean, the concern I have is more words sometimes makes more problems.
Yeah.
I mean, the fact
I
that
was just
we're
thinking,
using
yeah.
satellite, now do we have to define what a satellite is? I mean, you and I would know what it is, right? But, when it comes to enforcing the law or interpreting the law, I don't know if that would make it harder or
would be-
easier to
is-
do so. I
Was
don't
there
know.
any testimony from anyone that actually administers that has this federal-wide assurance?
I remember reading in the portal when we had the hearing in the House that there was some people that were, or the idea of considering moving that facility, but I don't remember the specific logistics of it.
Because I assume they might be familiar with this and might be able to explain to us that, but we have time to reach out to them, but that's.
Well, if we're gonna have a draft prepared by OLS for tomorrow, then we're under a tight time frame. So, again, is there any objection to going with what we talked about a few minutes ago?
No, what I went through, no.
Exactly,
Yeah. no.
exactly. So, house conferees? Okay. All right, I will go to OLS. Hopefully they'll still be open when I get done here today. And, again, thank you, everyone. So we will recess until 10:30 a.m. tomorrow.
Right.
Thank you. We'll reconvene in a few, we'll be convening on another committee of conference in a couple of minutes. Okay, I'd like to open the Committee of Conference for HB 377. Sorry for the delay, and thank you for your patience. And again, does anyone from the Senate want to start off with the changes you're proposing?
Sure, thank you. And I don't have my side by side. You do? Okay, all right.
Okay.
So 377 relative to healthcare professionals administering hormone treatments to puberty blockers, and then it was amended to recognizing the second Thursday in October as Environmental Health Day. One thing, it's important to point out that the Senate is in agreement with the intent of this bill, and that would end the medical procedure of giving minor children hormones to alter a child's gender. There were some things that we had made some changes on as we went through it. One was to remove the term puberty on there, and that was brought up to us because sometimes there was a medical need to adjust or slow puberty in a child, that we did not want to get in the way of that. The other thing that we had was, let's see, one of the things that we did was the grant, we added an amendment on that. I'll get to that at the end. So the other thing that we did was we grandfathered children that are already on this treatment. Anybody that has started prior to January 1st, 2026, we continued on that. The thought being twofold. One is that this practice, as of right now, is legal today. There are kids that have gone on and done this, whether we agree with the practice or not. But there are kids right now that are doing this, and they are, for lack of a better word, enjoying it. And we felt that it wasn't the state's position to remove that from them, as long as we were ending the practice. So at the end of the day, the practice will be ended. The other thing that we did add as well, which goes along with the fact that we're grandfathering these children, is that we added a private right of action. So a minor that was aggrieved by any violation of this can bring in, can file for damages and seek conjunctive relief, and that's through minority up to 2 years past minority. And then the other amendment, so that was amended, that we did that on the Senate floor. The other amendment that we added on the Senate floor was the Children's Environmental Health Day, which we felt really coincided real well with the intent of this bill, which is to protect children. And that would issue a proclamation declaring the second Thursday of October as Children's Environmental Health Day. And I think that we added sections 1 and 2 are going to take, sections 1 and 2 are going to take effect January 1st. And the remainder, which is the Child's Health Day, is 60 days after passage. So that's where we're at.
Thank you. Representative Kofal.
Thank you. So the packet that each of you just received a copy of, I think, includes the changes that Senator Rochefort just outlined. This, starting with the Senate version. At the top of page 2, we had a line in paragraph 3 has been stricken and replaced because, in my view, it was ambiguous, and I think attorneys could potentially argue it either way, that what was being grandfathered was the provider, independently of any patient they're treating. And what we wanted to be clear about was that this pertains to patients specifically. So the provider shall not be guilty of a violation of this section, provided that the patient had started treatment prior to January 1st, 2026. So it's been reworded to say nothing in this chapter shall prohibit a healthcare provider from continuing the direction or administration of medication or treatment that began prior to January 1st, 2026, and such continued treatment shall not be considered a violation of this chapter. That is one. I think the remaining concern, because there were, one of the key differences between the Senate version and the House version had to do with what I'll refer to as the weaning off language in the House version. Basically said there is going to be an end date to all of these treatments, so that somebody who's experiencing them now could avoid any detrimental health effects by cutting that off immediately, but there would be a weaning off period. The Senate version simply says if they started prior to that date, January 1st, 2026, then they are grandfathered forever, essentially. So until their 18th birthday, at which they can do whatever they want. So that is a concern. I think the House position is the House position. Having said that, one of our concerns about this approach, about the Senate approach, is that there could potentially be a sort of a rush to the gates that between now and January 2026, people decide that they've got to go make an appointment quick, get treatment, get their first treatment, and be grandfathered. So we would really like to see the effective date, both the effective date on the last page for section 2, as well as the date on page 2, what is now line 6 in the red line, treatment that began prior to January 1st, 2026, changed to prior to the effective date of this section. So those would be the additional requests that we would make at this point. I think would be focused on changing that effective date. I don't love the idea that we're going with grandfathering instead of weaning, but I think we all have a common interest in making sure that we're protecting children. So we feel like the House language goes further in protecting children, but we would very much like to see that effective date changed.
So what are you thinking for an effective date?
Upon passage. So essentially that sections 1 and 2 would take essentially the whole thing would take effect on passage, and page 2, line 6, again, this is the red line version, so line 6 is sort of the new section, the new paragraph 3, Roman numeral 3, would change treatment that began prior to January 1st, 2026, simply medication or treatment that began prior to the effective date of this section, and such continued treatment shall not be considered a violation.
Senator Rashadi.
Oh, thank you. Representative Koval, I appreciate what you're saying, but I'd like to just explain a little bit more about the process of this. People who are in this situation, they can't just, run out and look at an effective date. They have to go through a lot of care and counseling and different things like that. It isn't just that they're going to, there's going to be a mad rush and they're going to go immediately be put on medication. It doesn't work like that, with all due respect. And, also we have to take into consideration that we all, believe in parental rights, and, these decisions are being made by parents who, love their children. I think we made a fair agreement here, between you and Senator Rochford, and I just, really felt the need to say that.
Other thoughts? Senator.
So I hear what you're saying, and I think at the end of the day, we're all committed to stopping this therapy in the state of New Hampshire. Just thinking about some of the functionalities of, having an effective date, effective on passage. It doesn't matter my opinion on the actual underlying bill, but I'm just thinking, how do we implement this? So you've got facilities in the state that are doing this. They may be having patients, midstream. They may be taking appointments or have appointments in the book. I'm just thinking, if I was an office manager or if I was the policy director or quality assurance director at a facility that's doing this, it's hard, it would be very hard for me to implement something now. Having worked in the field, in the medical field, just knowing how a lot of the processes in medical are based on systems and processes and SOPs. I agree with you. The sooner the better. But I think if we do it on effective date, you're going to have people inadvertently violating the law, and that's not what we want. I would, I think I'm open for some negotiation there. But I'm just thinking about it more as a practical implementation process than anything else at that point.
Would you be amenable to moving that to a September 30th date then? September 30th, 2025?
September 30th? So I've got a no on this end.
And I'm happy to speak, if I may.
Yeah, go ahead.
To my
Go
note,
ahead,
thank
Senator,
you.
go ahead.
Thank you, Chair, and thank you, Representative Kofalt, for opening the discussion. And goes back to exactly what I said yesterday, that any of the families, the parents and the children that are entering into these treatments, it is, and we heard this during, well, I'm only going to speak for myself. I heard this during the testimony from at least one medical facility that came before us, as well as have spoken to care providers, that this is not just months, but sometimes years in the process before you actually get approval and you can start. So I think there's not going to be I believe there will not be a rush to the door. I think that we should kindly and humanely protect the families and the children that are that are undergoing this therapy right now, and set the date at the end of the year, and it'll move from there. I think what I heard is it's not an overnight decision there.
Okay.
So I think it's safe enough for appointments that are on the books, things that are already happening, but new people are not going to enter into the system. And I did bring this up when we were talking about another related bill yesterday that we're going to get to next. So it's not inconsistent. Thanks.
Representative Drew.
So I'll point out that argument is an argument in favor of upon passage, because if it takes that long, if there's this long process that people are taking to get to this stuff, then there's no real difference between on passage and January 1st, 2026. If it takes that long for people to get this stuff and it's this long process, then there should be no issues with stopping this particular treatment as soon as we pass the bill.
Yeah.
Sure, Senator.
So respectfully, I disagree, because what about families and their children that are already in this process? Will this stop? Will this protect them? And I think that what's the harm? I don't see the harm in building out a date, moving this through to the end of the year. I think that it is safe. If this were ever to be misinterpreted and stop somebody's therapy, that's not the approach that I want to take.
Representative Kofalt.
So as much as, I think we've made our case, as much as I would like to see that, I think that we all have protections. So, I think we would have to vote as sort of House conferees and Senate conferees. I guess, bottom line, if that is the position, that's what we need to do. It's not as much as I would like to see, but I think I could live with that.
Other thoughts? Representative Kesselring.
I don't know that on the specific thing, but I wanted to see, because I looked further down here on the Environmental Health Day on the second Thursday of October. I don't have a problem with it, but I looked at it and it's National World Sight Day. So it's all about blind awareness day. So I just don't know if we had an oversight here. So.
Senator Rashadi.
Thank you. Thank you very much. That's always been, it's a day too across the country, and it's always been that second Thursday in October.
Okay.
I suppose if we in New Hampshire wanted to make it separate from the rest of the country, but I didn't make that date.
Okay.
But thank you for the
I just
question.
want to bring it up.
Just one more thing to just to speak to the date, I did speak with in this whole process over the last several months, I actually did reach out to a provider who's doing this because this business, you hear all kinds of stuff, and I kind of like to get things from the horse's mouth. And I think the concern, and I brought up the concern. I said the concern is this is going to cause a rush to the door, and what is involved. So they and I can't find it, but they've mapped out their treatment protocol, and I use that loosely, their protocol for initiating this therapy, and it is months, in many cases a year plus. So I can appreciate the desire to get it started. I'm listening to my conferee here, but I don't think we're going to be. I mean, because at the end of the day, we're going to walk out of here, and this practice is going to stop in the state of New Hampshire. It might take a little bit, there might be some stragglers that get in, but at the end of the day, I think we can all feel comfortable that we've done a good job for the state of New Hampshire to stop this practice, and I think we can all come out of here winners with this.
Agreed.
Any other thoughts? So, if I'm hearing everyone correctly, then, and maybe I'm not, but I think I am, the proposal that just went around is exactly what we're in agreement on, or are there any changes?
This is what my understanding is that this is what we have agreed upon, yes. With,
Okay.
essentially with the red line changes at the top of page 2.
Right, the old section 3 being struck and the new section 3 being inserted.
Correct.
Okay. Does either side need a caucus, or are we ready to vote?
Ready to vote.
Okay.
Actually, can we just take a minute?
Oh, sure.
Can I have a minute?
Oh, sure, absolutely. You're not joining them, Senator Ricciardi? Or?
I don't think they need me for this. I think it's a.
You don't want Senator Ricciardi to join you?
You can hang with us.
Yeah?
I think I know.
Man.
Ms. Grant, could you come up for a moment, please?
I'd be happy to speak to why.
Sure, yeah.
Just briefly.
In terms of vote, does it have to be a roll call, or does it just? And we're going to go with the version as was earlier handed out. The main change is paragraph 3 on page 2. I'd ask for a vote at this time from the House conferees. All those in favor, please say aye. Aye. Let it show that we're all four are in agreement. And on the Senate side, Senator Rochford?
Yes, thank you very much, Mr. Chairman. And I just did, the Senate is in agreement. Senator Prentice is going to speak, but she will be replaced prior to sign off on the committee. And if she'd like to say a word,
I just wanted to explain to my fellow conferees, because of all the hard work I know that goes into this, I voted for the amendment when we addressed this in the Senate, and I support the work that's been done on the amendment, but I can't support the underlying bill. So that's why I'm going to vote against this and be replaced, but I want to thank everyone for their efforts on the amendment.
and
Thank you.
we will have somebody replaced that will sign off.
Okay, great, thank you.
Thank you.
Anything else to come before the meeting? Seeing none, I will adjourn this meeting. We have another committee of conference scheduled in about 18 minutes. So again,
There's a break?
again, thank you all very much for your participation and your help. Thank you, Senator Bouchardi. Thank you, Senator Prentice, for all of your work on numerous fronts. Thank you, Senator Rochford. Among the House conferees, is there any objection to House Bill 377 FN going on consent? No. No. Representative Kesselring, any objection? And I have no objection. So this will go on the consent calendar in the House.
All right, Chairman McDonald had asked me to open this hearing, or this committee of conference in his absence. So I hereby open the committee of conference on House Bill 712 FN. And I would ask Senator Rochefort if he could go through the Senate version as we did with the last bill and just talk about key changes in the Senate version of this bill.
Now you put me on the spot now.
I got my side by side. Here you go.
Okay. As we recall, the underlying bill was limiting breast surgeries for minors relative to, and then there was amended to relative to residential care and health facilities, and amended to relative to collection and reporting abortion statistics. So going through the main bill, the Senate version was limited breast surgeries to minors only to those procedures needed to treat malignancy, injury, infection, or malformation, and those needed to reconstruct breasts after such procedures. The change on the definition of transgender breast surgery added that only in such cases where there's no medical diagnosis recommending such surgery to remove breasts or increase the size of breasts. The Senate version adds that cases where no diagnosis, where there's no medical diagnosis recommending such surgery to remove the breasts or increase the size of breasts. Moving along, it was under RSA in conjunction with the Office of OPLC. The Senate, so the House version said a violation of this subdivision is unprofessional conduct and is subject to discipline by the Board of Medicine and or the Office of Professional Licenses and Certification. The Senate version removed the and or and put it under the Board of Medicine, which is where that discipline would take place. The House version said any person who negligently or willfully violates or assists in the violation of the provisions of the section may be subject to liability for damages as provided by law. So this says that a violation of this subdivision shall not be grounds for additional civil or criminal liability, which I think we're going to talk about in a minute. Let's see. Enforcement. The House version said any referral for or provision of gender surgery to an individual under the 8 years of age is unprofessional conduct and is subject to discipline by the appropriate licensing entity or disciplinary review board. The Senate version removes the referral for and would refer to any provision of gender surgery to an individual under the 18 years of age. So we just remove the referral for. So going on to the First Amendment, residential care and licensing facilities, the Senate version said to help assure quality care of residents in licensed residential care facilities, such facilities shall maintain a quality assurance program for its residents as set forth in this section. I think we're going to talk about that in a minute. And then the collection of abortion statistics, which is a identical words from SB 36 relative to collection and reporting of abortion statistics by healthcare providers and medical facilities. I know there's some nuances there that we're going to talk about soon. And then the last thing we just want to make sure we address is section 14 of this section shall take effect January 1, 2207. And I don't think any of us will be around to see the implementation of that law when it comes. So that's where we're at.
So if I may, I want to go through the red line version that has been handed out to everyone. And again, I think some of this is going to be a repeat of what we talked about yesterday, but essentially the top of page 2 where it says only in such cases where there is no medical diagnosis recommending such surgery to remove the breast or increase the size of the breast. The House conferees were concerned that that was overly broad. And so we are recommending to change that to except in cases where such surgery is physiologically necessary or is reconstructive in nature. Physiologically necessary refers to interventions, procedures, medications, or therapies essential for maintaining or restoring normal physiological function, preventing life-threatening conditions, or ensuring survival by addressing critical body needs, such as stabilizing vital systems, correcting severe imbalances, or supporting essential biological processes. Going down to lines 24 and 25, this is section 1, Roman numeral 3. We changed the language to the language proposed by Senator Birdsall yesterday. A violation of this subdivision shall not be grounds for additional civil liability except as allowable by this chapter and shall not be grounds for criminal liability. Next page, we're on to page 3. Under enforcement, we have the existing Senate language for Roman numeral 1, then Roman numerals 2 through 7 are the private right of action. This is identical language to the language that we just saw in House Bill 377. So it would align those two sections of statute. Moving on to page 5, collection of abortion statistics. Rather than repealing and reenacting RSA 32949, we are amending 32949 to include the following. The remainder of the SB 36 section, the abortion statistics section, remains the same with the exception of paragraph 5. Any medical facility that willfully fails to comply with the provisions in this section shall be subject to an administrative fine of $100 for each business day of noncompliance for a first offense, and shall be subject to an administrative fine of $1,000 for each business day of noncompliance for any second or subsequent offense. And then lastly, we have line 16 of that page. Section 14 of this act shall take effect instead of January 1st of 2207. We want to say July 1st of
2027.
27. Yes. So those are the proposed changes.
I'd like to call for a caucus. Sorry.
Representative Kessling?
Yep.
What?
Yes, I'd like to request a 5-minute caucus.
Thank you.
Okay.
Okay, I'd like to reconvene the Committee of Conference for HB 712FN, and who'd like to go first? Senator Roachford.
So I think Senator Kofalt approached us, or yeah. Happens to me all the time.
He's out there with you so much today.
I know. So I guess, do you want to explain to that what you brought forward?
Sure. So the section of concern was the enforcement section. Thank you. On page, this is the enforcement section for the abortion statistics portion of this bill. So page 6, lines, well, let's say 9 through 12. So the concern was that this language encompasses non-compliance, which would presumably mean failure to report. It doesn't address the sort of reporting false information. And so there was a concern about wanting to address that situation. Now, we actually don't need to create a new penalty. We can simply reference an existing penalty in statute. 638, RSA 638.3 addresses this and essentially says, false, falsifying information with the intent to deceive or to conceal wrongdoing is a misdemeanor. And so the proposed language would be to replace Roman numeral 5 with any medical facility that knowingly and willfully fails to comply with the provisions of this section shall be subject to an administrative fine of $100 for each business day the facility remains in noncompliance. And that would be followed by any individual who knowingly and willfully provides false information pursuant to this section shall be guilty of a misdemeanor under RSA 638.3. So simply referencing and acknowledging that we have a statute that addresses falsification of information. So our proposal would be to replace Roman numeral 5 on page 6 with the language that I just read.
Sure. So just to be clear, 638.3 is already in law. So any type of fault, I mean, if any data was falsified today, they would be subject to a misdemeanor. So I guess one of the questions that we had is really, what does that add to the underlying bill if it's already law?
I think more than anything else, it establishes legislative intent that this is, the expectation is that, compliance not only means reporting, it also means reporting accurate, truthful, and complete information.
Sure. And then the other thing I wanted to know, I mean, we did talk about earlier today, actually a more substantial fine for that, but we would be agreeing to the, what the administrative fine that is the Senate's position, and then just restating what is already law, 638.3.
Correct. And so, I mean, essentially that simply said, the existing statute says tampering with public or private records. A person is guilty of a misdemeanor if, knowing he has no privilege to do so, he falsifies, destroys, or removes or conceals any writing or record, public or private, with purpose to deceive or injure anyone or to conceal any wrongdoing. So we're essentially just referencing that statute. We're saying that statute applies in this situation. So it's clear and unequivocal, but we're not adding any new penalties to law under this circumstance.
Yeah, sounds agreeable to us.
Okay. So I think then to summarize, on page 2, we have, except whether surgery is physiological, necessary, or reconstructive in nature. This is the redlining at the top of page 2. 2/3 of the way down that page, except as allowable by this chapter, shall not be grounds for criminal liability. And pages 3, well, mostly page 3, top of page 4, we have the addition of the private right of action, or the right of action, exactly as it appears in House Bill 377, which we dealt with an hour ago. And then we are, instead of repealing and reenacting 32949, we are amending it with the abortion statistics. And then we're adding the language that we just referenced on page 6, Roman numeral 5. And then we are changing the effective date for section 14 to July 1st of 2027.
Yeah.
Those are the
That
changes.
covers it.
Section, so section 4 does not change, right, on page 6? Under effective date, it's just section 3, was correcting that typo.
Correct.
Correct.
Okay. Okay, any other thoughts, or are we ready to vote?
Yeah.
Okay,
Anything else?
House conferees, all those in favor?
Aye.
Aye.
Aye. And from the Senate?
Aye.
No.
Okay, and will that be the similar situation as,
Yes. Senator Prentice will be replaced prior to sign off.
okay. All right, well,
Consent?
what's that?
Can we put our consent on the House side?
Yes, yeah, thank you. Any objection to consent?
No objection.
Okay. All right, we will put this on consent, the consent calendar in the House. And Ms. Grant, am I forgetting anything? Okay. All right, I will go to OLS, probably in the morning at this point, and get this done. And
Sounds good.
thank you, everyone. If there's nothing else, we stand adjourned.